Parliament, courts, and the government, the love triangle. We will look at the courts first and see how they construct legal opinion using the doctrine of parliamentary sovereignty. As we looked at the manner and form principle in the previous lecture, we saw that it is important that the Parliament enacts legislation in a manner that is in accordance with the Parliament Acts 1911 and 1949. Even with the manner and form principle in place, the courts are not willing to look into the proceedings of the passage of a bill. In Picken versus British Railways Board 1974, Mr. Picken brought a case that an Act of Parliament should be put aside because the manner in which the private bill was passed was contrary to the Parliament Act of 1911. Mr. Picken was trying to retrieve the land that he was denied by the British Railway by challenging the legislative procedure. In the judgment, House of Lords held that the claim must fail. The House based its judgment on 3 lines of reasoning. The first reason was that the function of the court is to interpret and apply the laws enacted by the Parliament and not to question its validity. The second reason was that the court was not willing to challenge the integrity of the Parliament. The court held that the Parliament was capable of regulating itself. The third reason was that there was no difference between a public act and a private act. The court in no way can involve itself in investigating the manner in which the legislation was passed. This case implies that an act of Parliament cannot be questioned by the court, but on the other hand, anything that is not an act of Parliament is open to investigation by the court. For example, in UK, the bills are presented for royal assent after they have been passed by both the House of Commons and House of Lords. But what if the Parliament decides to skip House of Lords and send the bill directly to the Queen for royal assent? In Jackson versus Attorney General, the question that was raised in front of the House of Lords was whether a bill that has been passed by following the Parliament Acts 1911 and 1949 but has bypassed the House of Lords is a valid act. The act under question banned the hunting of fox and was called the Hunting Act. The case took a different direction then in Picken versus British Railways because the Attorney General fighting the case on behalf of the government did not challenge the act of bringing the case to the court as being an illegal act. In this case, the court took upon themselves the responsibility of looking into the proceedings of the Parliament. This investigatory act of the court was contrary to the Bill of Rights and common law precedent. However, the courts argued that it was not investigating the parliamentary proceedings, but was instead answering a legal question by providing their interpretation. The legal question was, can the Parliament use the Parliament Act of 1911 to pass the Parliament Act of 1949? Both of these acts are of constitutional importance and were used to pass the Hunting Act. The House of Lords found that the Hunting Act was passed in accordance with the Parliament Acts of 1911 and 1949. The judges raised a lot of interesting points. We will look at them again in future lectures, but for right now we will focus on the points raised by Lady Hale in her obiter statement about the parliamentary sovereignty. She stated that unless the Parliament makes its intentions crystal clear when interfering with fundamental rights of the citizens, the court will decide in favor of the fundamental rights. She also made the point that the Parliament has limited its sovereignty by passing the European Communities Act 1972 and the Human Rights Act 1998. By looking at this case, we can conclude that the relationship of the Parliament with the courts have changed over last few decades. The Parliament has given the Supreme Court a bigger role in guarding the constitutional arrangement of UK with the passage of the Communities and the Human Rights Act. Furthermore, the Supreme Court of the country has moved out of the House of Lords and has become a more independent body with the passage of Constitutional Reform Act of 2005. These paramount changes in constitutional arrangement of the country has forced the judges to look at the parliamentary sovereignty in a less orthodox way. The government is responsible to forward the legislation that is debated in the Parliament. If passed by both the houses, the bill is sent for the royal assent. as we know that the government sits in the Parliament and is part of the Parliament. In theory, the Parliament is supposed to restrict the powers of the government by having debates in both the houses on the legislation forwarded by the government. But in practice, the Parliament is normally overtaken by the majority party, who also forms the government. Interestingly, in 2010 elections, neither of the two major parties could form a majority, so they had to form a coalition government. The extent of the power of the government can be realized by looking at the Scotland referendum. This will provide us a bottom-up view of the doctrine of sovereignty. The coalition government held a referendum in 2014 for the independence of Scotland from the United Kingdom. The referendum can be seen as having the power to alter the constitutional arrangement of UK by giving independence to a devolved government. It is interesting to note that Scotland already enjoys a lot of legislative power that has been shared by the Westminster Parliament with the Scottish Parliament. The referendum was a landmark democratic success and the largest turnout of voters in the history of any elections or referendums. The turnout was 86% and 55% voted against the independence of Scotland. It is really interesting to note that the Scottish constitutional lawyers see the parliamentary sovereignty as a particularly English idea having no ground in the historical record of Scotland.